As an employee of a private company, are you bound by an employment or indemnity bond? And will you have to pay the entire liquidated damages to your employer if you leave before the specified time period? The short answer is no. If you want to learn more about the Supreme Court's judgment and the reason given by the Supreme Court in arriving at the judgment, watch till the end. Well, if you believe news media outlets and social media influencers, you might think that modern day slavery is here, but that has actually been misreported by them because none of them have actually read the judgment properly. All this controversy arose when Supreme Court passed a judgment on 14th May 2025 in the matter Vijaya Bank and another versus Prashant B, Narnaware. We'll discuss about this case in a stage-wise manner. I'll tell you about the facts, the legal issues involved, the court's reasoning, and whether this case has any value as a precedent. Let's talk about the facts of the case. The employee, Mr. Prashant B. Narnaware, joined Vijaya Bank in 1999. In 2006, the bank brought out a recruitment notification for certain posts containing clauses 9W and 11K, which required any employee to sign an indemnity bond for rupees 2 lakh rupees and indemnify the bank of such amount should such employee resign from the employment before the lapse of 3 years. The respondent, on his confirmation in 2007 for the post of senior manager cost accountant, for which he had applied pursuant to the notification, was bound by restrictive clauses in the notification. The respondent resigned from employment in 2009 and joined IDBI Bank. He paid the sum of rupees 2 lakh under protest, and simultaneously he filed a writ petition instead of a civil suit. He filed a writ petition before the High Court challenging the restrictive clauses of the notification for being violative of Articles 14 and 19 of the Constitution of India 1950 and Section 23 and 27 of the Contract Act. A single judge of the High Court, while relying upon the judgment of the Division Bench of Karnataka High Court in KY Venkatesh Kumar vs BEML Limited, allowed the writ petition. The judgment of the single judge was upheld by the Division Bench of the High Court, against which the bank approached the Supreme Court. Now, when this case came up before the Supreme Court, the court identified two key legal issues. First, whether the condition was in restraint of trade under Section 27 of the Contract Act, and second, whether this condition was opposed to public policy and thereby contrary to Section 23 and 27 of the Contract Act and violative of Articles 14 and 19 of the Constitution. Now, with respect to the first issue, the court differentiated between restrictive clauses which operate during the period of employment and post the employment. The court held that restrictive clauses during the period of employment are valid and enforceable. In para 15 of the judgment, the court says, in view of these authoritative announcements, it can be safely concluded law is well settled that a restrictive covenant operating during the subsistence of an employment contract does not put a clog on the freedom of a contracting party to trade or employment. Then in para 16, the court says, a plain reading of clause 11K shows restraint was imposed on the respondent to work for a minimum term 3 years and in default to pay liquidated damages of rupees 2 lakhs. The clause sought to impose a restriction on the respondent's option to resign and thereby perpetuated the employment contract for a specified term. The object of the restrictive covenant was in furtherance of the employment contract and not to restrain future employment. Hence, it cannot be said to be violative of Section 27 of the Contract Act. Now, with respect to the second issue, the court held that this clause was not against public policy for the following reasons. Number one, that the clauses are fair. The court held that public sector undertakings, please remember this word as this is very important to the analysis which we'll do later on. So yes, public sector undertakings like the appellant bank needed to compete with efficient private players operating in the same field. To survive in an atmosphere of deregulated free market, public sector undertakings were required to review and reset policies which increased efficiency and rationalized administrative overheads. Ensuring retention of an efficient and experienced staff contributing to managerial skills was one of the tools inalienable to the interest of such undertakings, including the appellant bank. In para 27, the court says, this prompted the appellant bank to incorporate a minimum service tenure for employees to reduce attrition and improve efficiency. Viewed from this perspective, the restrictive covenant prescribing a minimum term cannot be said to be unconscionable, unfair, or unreasonable, and thereby in contravention of public policy. The second reason which the court gave was that PSUs have a different system of appointments. So in paragraph 29, the court says, the stance of the appellant bank is neither unjust nor unreasonable. The appellant bank is a public sector undertaking and they cannot resort to private or ad hoc appointments through private contracts. An untimely resignation would require the bank to undertake a prolix and expensive recruitment process involving open advertisement and fair competitive procedure. The third reason was that the amount involved was not so huge. In paragraph 31 of the judgment, the court says, respondent was serving in a senior middle managerial grade having a lucrative pay package. Judged from that perspective, the quantum of liquidated damages was not so high so as to render the possibility of resignation illusory. In fact, the appellant had paid the said quantum and resigned from the post. So my analysis of the judgment and whether it applies to private company employees. Firstly, every case has different facts and this cannot be seen as a binding precedent on each and every case involving private employees. As you saw before, much of the court's reasoning in the judgment hinged on the fact that recruitment in a PSU is a multi-stage process, and when an employee resigns, it requires huge amount of expenditure and replacement cost is really high. So these kind of clauses are already there in various other government services like the armed forces and also in the airline industry where companies incur significant expenditure on training pilots. As for private companies, there have been several cases where employers have had these kind of employment bonds and they have managed to recover only the actual training cost that was incurred on training the employee, not the full bond amount. Secondly, the issue only before the court was whether this clause is illegal or not. The court didn't have the opportunity to examine the merits of the case or any evidence on the quantum of damages or other factors. Because the aggrieved employee had filed a writ petition and not a recovery suit, there was no cross-examination held where each party would have had to prove its claims. If Vijaya Bank was claiming liquidated damages, they would have had to prove as to how much damages did they actually suffer. Now thirdly, in this case the employee had already paid the amount and then later on he filed a writ petition. So this clause didn't really hamper his future employment. What this judgment really clarifies is that post-employment restrictive conditions are violative of section 27. So all your non-compete agreements now go straight to the trash can. But now say for example, if there was a clause that the employer will not give the employee their experience letter or the NOC if they don't pay the bond amount, that would be termed as affecting their future employment, and the clause could be held violative of section 27 of the Indian Contract Act. I would like to conclude by selectively quoting one line from the judgment itself, where the court says, "It is trite that judgments cannot be read as statutes and have to be applied keeping in mind the factual matrix peculiar to each case." This brings me to the end of the video. Thank you very much for watching. Leave your thoughts below.